Well, thank you for joining the webinar, everyone. It is due to start shortly, so the usual rules: please mute your microphone, switch off your camera, avoid taking control of the PowerPoint slides, please, and pose any questions via the chat function at the end. The idea is that we will email out copies of the slides and also some companion notes after this talk. So if you're the sort of person who prefers just to listen rather than taking notes, feel free to do so. Standard disclaimer applies in relation to anything we say in relation to this seminar. So administration's update, a year in administrations. I'm delighted to welcome you to the start of Guildhall Chambers Autumn Insolvency Webinar series. Ordinarily, we would like to offer up an annual insolvency seminar, which you can all attend, but for obvious reasons, we're not doing that this year. So what we decided to do is convert some of the content that we intended to give on one day over a series of webinars over a space of a few weeks, and today's is the first on menu. I'm even more delighted to have Joanne Rumley join us giving this talk. Joanne heads Foot Anstey's restructuring and insolvency offering. We've been doing a slot on administrations at our annual seminars for longer than I can remember, and they remain as popular as ever. Catherine Burton, who is now ICC Judge Burton, did them for a number of years with a member of the insolvency team. Joanne, as I understand it, has no judicial career aspirations, but having had a chance to consider the slides she has produced, I've no doubt that, like Catherine, she will outshine the Guildhall speaker, and like Catherine always did, come up with some snazzy slides and snappy one-liners. So I'm looking forward to hearing what Joanne has to say about a year in administrations as much as you are. In terms of the content for today's talk, we've decided to split it up into three. First part, we intend to look at defective administration appointments again, plus. The second part of the talk is looking at the rule in ex parte James and wider compliance issues in relation to administrators. And the third is looking at the Prepack reforms, which I'm sure all of you will have seen were announced in October of this year. And we have some draft regulations, which I'm sure all of you will be interested in hearing more about. So that's the broad overview for the talks that we intend to present. You will have noticed as part of that menu that there's nothing in it which is anything to do with COVID-19 cases. So we are COVID case free, and deliberately so for the purposes of this talk, because we thought probably people have been webinar'd out on that subject and would prefer to listen to something different for today's talk. So, Joanne, over to you, please, for the part one of our talk.
So good morning, everybody. Thanks, Hugh. I don't know whether I've got any one-liners, but we'll see how we go. But hopefully I've got a few slides that are a bit interesting. So here we go. If I can move the slides.
I think you should be able to take control.
I have, yeah.
Is that not working for you?
No.
Do you want me to?
Yeah, you go with this. You drive the slides. Brilliant. So next slide then. So I thought we'd do a bit of we will concentrate on the 12 months that have just been on these administration cases, but I just kind of got to thinking when Hugh asked me to do this about administration as it is in Schedule B1, and it made me cast my mind back, next slide please, to 2003 when these came into force. And our slides are not moving. Hugh, am I in control or you?
You asked me to?
I am.
You are now. Okay.
I am.
You take control.
Brilliant.
Then, yeah.
So here we are, 2003. You're thinking, goodness me, what has a lady with a baby got to do with it? Well, in 2003, when the administration, the new regime came in with the Enterprise Act, I was on maternity leave. And I remember thinking and getting very, very stressed on my maternity leave about these new provisions. And when I came back from maternity, would I be able to do these new appointments? And of course, the rest of the world would have been doing them for 6 months already and would know exactly how to do them. And I would be very much behind the curve. So this sort of came into play a few weeks ago when my little baby turned 17 and I suddenly became a driving instructor, because I am going to mention the COVID word. In COVID, driving instructors are not allowed to operate at the moment. And so it is me, and it is pretty scary, I have to say. But that then made me think about this whole administration journey, because the last 17 years of what we think is a fairly new procedure has been a pretty bumpy ride. Here we are on our road from 2003 to 2020, and there's just a snapshot of the cases that are mentioned often around administration appointments, and a bit wider around the sort of jurisprudence that sits around an administration. And if you just focus on those cases on the far right of the slide, most of those in blue have happened in the last 12 months. So I needn't really have worried, need I, about the panic of not being able to do these appointments when I came back from maternity, because it strikes me that all of us are still very much the learner driver. And in fact, I think the judges feel they're in the same place. Here's a quote from Norris in Euromaster, telling us it's a very complex and technical area of law. We've got conflicting decisions. So is there any wonder we don't know how to drive the car yet? And oftentimes we're under a lot of pressure, aren't we, to deliver these decisions very, very
Joanne, I missed the for some reason, I don't know why, I missed the slide with all the cases on it, and it may have just been me, but do you just want to take everyone back to it so they can see it again?
Is that showing for you?
It's showing on mine now. Yeah, it may have just been
right.
because I was trying to do the slides at the same time as you. But I'd assume when I looked at that slide that it was actually the route that you were taking as driving instructor.
Yeah, well, it feels a bit like that sometimes, especially when she's in the ditch. But yeah, so moving on then, there's the quote from Norris, these complex and technical decisions. So over the last 12 months, we've had a number of decisions, and I'm just going to skirt over a few of them. I'm not going to give you loads and loads of facts about them, because what I really want to do is try and draw out the themes of where I think the last 12 months have got us to, and I'll try and pull that together at the end of the section on the cases. So I want to start with this one, Nationwide Accident Repair Services. This is a case really about the sort of ability of a director to make an appointment, or to come to the decision to make an appointment in the first place. And we've got a holding company, and this was to do with the holding company of a number of trading subsidiaries. And the trading subsidiaries had all managed to get themselves into administration using the out of court appointment route. But the holding company, unfortunately, had a single director, a sole director, but it had articles that required it to act by a quorum of 2. And of course, it didn't have 2 directors. And we all know from the line of cases that have gone previously that where you've got corporate governance of that nature, you really need to be able to comply with it in order to be able to make an appointment. It was very evident that the company was clearly insolvent. It was both cash flow and balance sheet insolvent. In fact, it owed the bank somewhere in the order of about 32 million. And it was also very evident on the fact that the purpose of the administration would be achieved. There was a very detailed submission put forward by the insolvency practitioner about how the prepack that they were proposing and the sale would benefit the creditors. And it was a substantial difference between an alternative process. They tried really hard to get their shareholder to appoint a new director, and they'd also asked the shareholder if they'd approve a change of the articles, but for whatever reason that wasn't possible. So it came before the judge as an application. So we're not using the out of court process, we're applying. And the judge sort of looked at the case authorities and appreciated the need for strict compliance with the articles, but he started to weigh up actually the necessity of getting this company into administration and the protection of the creditors against the corporate governance. And in this case, the judge decided to exercise his discretion, I think in part based on the brickvest decision that had gone previously, to say that even though the legislation is drafted so that it talks about directors having access and the case authorities having stressed, if you like, the need to comply with the corporate governance, he was very much of the duty that even a single director owes duties to the creditors, such that if you've got an insolvent company, they've got to be in a position, and in fact he says almost duty bound, to find a way to get the company into insolvency. And on that basis he exercised his discretion in favour of making the appointment. There's just a postscript there on the bottom of the slide. It's probably worth insolvency practitioners reading the sort of final page of this judgment. There was a little rap over the knuckles for the insolvency practitioner who and really the parties in general, because this application came on after hours. It was a very late night request at the last minute of the judge, who did sit in the evening to hear this. And the pressure had all come about by a sneaky provision that had been put into the sale agreement, requiring the completion of the prepack by a deadline. And that deadline, it was said, had been artificial. And the judge felt very uncomfortable about the fact that when you're trying to rationalize all of the cases that have gone before and the conflicting authorities, and you're trying to get to the right outcome for the creditors and for the process, that the judge shouldn't be hemmed in by an artificial time frame. So beware, you insolvency practitioners, about creating urgency when it might not be needed. So moving on, I thought we perhaps better spend a bit of time on the great CE filing system. This has revolutionized our world, hasn't it? So easy, just fill it in from your desk. No more trainers needed by the trainee to get to the court office before it closes at 4 o'clock. I think we've all been there at some point. But in practice, the CE filing system has created quite a considerable amount of case law, because it's perhaps not as easy as it should be. So I just want to recap 12 months. So had I been doing this talk 12 months ago, where were we at? Well, we had the lovely decision of Key Worker Homes. We also had the case of Re All-Star Leisure. And I think probably 12 months ago, I would have been sitting here saying, it's very straightforward. A qualifying floating charge holder cannot file an out of hours appointment using the CE filing system. Why not? Because Key Worker Homes tells us that Rule 320 to 322 of the insolvency rules is the mechanism which has been designed by Parliament, intended by Parliament, for the qualifying floating charge holder to use. And you will know that that provides the separate route where you file by way of an email, and then you go the next day with your paperwork or submit your paperwork to follow. So you do not use the e-filing system. Clear, no problem. The cases were also clear that if by accident the qualifying floating charge holder had used the e-filing system, that could be cured. It wasn't a fundamental defect, so the judge could make an order. I think it was also clear this time last year that directors could e-file a notice of appointment 24 hours a day. That's because the Key Worker Homes decision took a very broad approach to the fact that we're able to e-file. So where the practice direction tells us that e-filing is an appropriate method for delivery, then that system is open to us. And the fact that there was nothing in the legislation to tell us that we couldn't do that, or that we must use a different system, must mean that it was available to us. So there we are, 12 months ago. Where are we today? Well, interestingly, along comes this little case, Sim and Company, and this is from February this year. There wasn't a necessity in this case for a notice of intention to be served, so we were going straight to notice of appointment. And of course, because of key worker, I guess the lawyer that was filing filed at 17:36, so very much out of court hours. And what then came is under the court chancery guidance, obviously if something's filed after 4 p.m. It has to go before a judge, and the judge then determines what the position is going to be. And the judge in this case ordered that the date for filing should be the following day at 10 a.m. What's interesting about this case is that this is probably the first case that really explored the sort of interplay between the Insolvency Act, the insolvency rules, and how the practice direction 51.0 sits, and how they all play together. So when we look at the practice direction, and that shouldn't necessarily be our starting point, but I'm going to start there. It's express that for a qualifying floating charge holder, they should not be using the out of court route. That's fine, that's a tick, because that's the same as where we were with the key worker decision. So we're all happy about that. Rule 320 is the way we approach this. We then drop down to the legislation, and let's not forget the legislation is where this starts. That's what provides the framework to enable the appointment to be made. And the judge in this case agreed with the Skeggs Beef decision, which had kind of been dismissed in the key worker homes case. Well, not dismissed, it had been considered, but then a different approach was taken. And Skeggs Beef had said, look, it's absolutely clear that a notice of appointment must be made pursuant to the rules. And just because you've got a practice direction saying something else, that should not dictate the way we approach this. The way we should approach this is through the legislation. And this decision also supported the views of our friend Burton, from the H.J. Henderson decision, where she'd looked very clearly at the obvious intention of Parliament. And she's saying that because Parliament was express in its provisions around the qualifying floating charge holder, the fact that it was absent in relation to a director's appointment probably meant that therefore a director shouldn't be enabled to have this right. And when you think back to 2003, and I'm old enough to do that, you think about what was in place before, you can see how this makes perfect sense, because the whole point of a qualifying floating charge holder having this this special right to appoint out of hours, came out of the fact that they'd got the right at any time underhand to appoint an administrative receiver just by way of a deed of appointment. So I personally think where that judicial debate has got to on out of hours is probably right, but we shall see what the next year brings, I guess. I then just want to look at Stateborn, Cryogenic, and also Carter Moore, because I think this is important, but we won't dwell on it. These two cases were all about, if you like, the technicalities of using the CE file system. So unfortunately, I guess under pressure, the person who was uploading the documents inadvertently clicked the wrong drop-down boxes. So in one of these cases, we got a wrong court referenced, and in another of the cases, the NOI had been filed correctly, but when the NOA was filed, it was filed as a new sort of procedure, new matter, rather than being an existing matter. And so both of these were defects, if you like. And so what happens, and I suspect we've all been there, you get the really unhelpful message back from the court office, which makes your heart sink, because the appointment that the insolvency practitioner is so desperate for you to file and it's urgent, comes back and says filing not accepted. Well, in these two cases, the lawyers or people uploading them in question realized they'd made a mistake, and they did work quite hard to rectify the mistake. So they tried resubmitting the filings, and what that meant was that we'd got multiple things filed, some of them after hours, and that's why it became before the courts. The judges in both these cases, and Stateborn Cryogenic had the benefit of considering the Carter Moore decision. Both said, look, this is a technical procedural error of use of the CE filing, and the judge has a discretion under the practice direction using CPR 310 to be able to rectify that. And in both cases, what they said is the original filing that was made at the original time would be what the judge would endorse as being the date and time for appointment. So I guess that gives me a bit of peace of mind that if a mistake's made on the CE filing system, that's probably the most easily curable bit than some of the more fundamental mistakes. So then, whizzing on, we've had 3 more judgments during this year, bringing back very familiar issues. We've got the 10 business days. When does it start? When does it finish between the NOI and the NOA? We've got that good old chestnut, the FCA consent for a regulated company. And we've got a case which is around failure of service of the NOI on a qualifying floating charge holder in this case. 10 business days. Let's deal with that one first. It's very clear in the Act that it says beginning with, and I've underlined that, the date that the NOI is filed. Key Worker Homes had taken, so only 12 months ago, Key Worker Homes had taken a very expansive approach. And so they talked about this needed to be clear days. So you do not count the first day, the day this is filed. Interestingly, I pulled out the note that my team wrote when I was away on maternity leave in 2003 about all the time limits in Schedule B1. And first and foremost in my table of time limits is beginning with. And the note very clearly says, so this is 2003, beginning with commences on the day the NOI is filed. Well, I'm very pleased to say that we were right then, and if this judge is right, we're right now. And it's got me into trouble over the years because I've had lots of IPs saying, are you sure you've got that right? We just need an extra day, and I've been very determined, no, we start by counting on the day the notice of intention is filed, and that is indeed what this case, Stateborn Cryogenics, has decided. It's also decided in agreement with Key Worker Homes that if this bit is not correct, that is a defect, which is an irregularity, and can be cured by the judge, provided there's not a substantial injustice caused. The FCA consent, however, is a different matter. You'll appreciate we'd got MTB Motors and we got RISI at risk before now, and then this case ARG comes along. Bit unfortunate, this case. ARG is A.R.G. And when the diligent person who was making the appointment did the search of the FCA register, unfortunately, I think they put ARG in without the dots, and because of the punctuation, it didn't come up. Therefore, they filed without FCA consent, and they actually filed NOI and NOA before it was later picked up on one of their internal file reviews. This case has gone back to MTB Motors, which basically says that the requirement that the consent of the FCA is obtained is a statutory requirement. It's contained in section 362A of the Financial Services Markets Act, and because it's a statutory requirement, it was intended by Parliament, therefore it has to be complied with. It's fundamental to the genesis of the appointment, and therefore if you don't file it, your appointment is invalid. This case then went on to make a retrospective order. We all know how uncomfortable judges are with the retrospective orders and making them, but nevertheless, for a fundamental defect, well, it's not a defect, it's an invalidity and nullity, they will make a retrospective order. And this case also says that that will be the position about retrospective orders unless and until the Court of Appeal decides otherwise. This judgment I would highly encourage you to read because it sets out all the jurisprudence, the history of all of the cases and how the thinking goes. And so it's if there's one, well, actually there's two judgments to read, but this is one of them. And then the final point, and Hugh, I'm conscious of time, is the failure to serve the notice of intention on the qualifying floating charge holder. When I read this case, I was quite shocked. I think I sort of read the first 3 pages and I thought, my goodness me, failure to serve a notice on the qualifying floating charge holder, the most probably important person in the whole administration, our key stakeholder. Surely that's got to be an invalid appointment. Surely, Joanne. And then I carried on reading, and when I got to the end, I thought, actually, I get this now, and this case is, for me, probably unlocked where I think the jurisprudence has got to. So what the judge said,
this is the next slide, I think, isn't it, Joanne?
No, it's not.
Or is it this one?
It's the bottom of this slide. That's right. And this is the token house decision. This is the second judgment I would encourage you to read. This is a judgment of a lower court, but actually the judge produces an absolutely brilliant and very concise summary of the cases. And he sits it in an appendix at the back. So do spend some time. Where he gets to is this. He says, look, I'm going to rely on the Euromaster decision, and I am looking at how Parliament wrote these provisions in Schedule B1, and I am going to divide Schedule B1 into sort of 2 parts for a director's appointment: paras 22 to 25 and paras 26 to 32. And paras 22 to 25 give us the power to appoint, the things that have to be there in order for the appointment to be made. And it takes the view that those are absolutely fundamental. If those are missing, it will become a nullity. The appointment is a nullity. And then you'd be into your retrospective order. He then looks at paragraphs 26 to 32, and he says, these are, if you like, the procedural requirements of how those powers have to be exercised. And of course, you'll know that the service of the notice of intention on the qualifying floating charge holder is all about how we have to serve. So it's in paragraph 26, therefore it's procedural. And if we don't comply with the procedural, that would be treated as an irregularity, and therefore you then look at substantial injustice. So in this case, he says, look, this appointment is valid. It was a procedural defect. Nevertheless, it was a defect. And because it was a defect, I've got to rectify that. I've got to make that right. So I've got to ask myself the question, how do I cure it? And when you think about what the purpose of the NOI is, it's not really to stop the administration going ahead. It's to allow our bank, in this case, to appoint or choose to appoint their own insolvency practitioners. So how does he cure it? He allows the administrators to be replaced by the chosen people of the stakeholder. So the end result is exactly the same as it would have been had the NOI been served. So again, whilst my starting point was surely not, I actually get this. I get where this judge has got to, and I understand why. That careful balance between making sure that you don't have a disproportionate result while still protecting the rights is really important.
So we think probably that's a good decision, don't we, Joanne, ultimately? And actually it contains a useful review of all the different conflicting authorities, isn't it?
That's right. Yeah, that's right. And I would urge people to read it because it's a really easy read. So just pulling the themes together. At a very basic level, there are, for me, some things which are in our gift and our control. The first is the most obvious that Snowden pointed out in the Carter Moore case. Look, it's very expedient to ensure that you do not file a notice of appointment out of hours. Do it when the court's open. If it's 10 to 4 and you're really not sure whether it's going to go through, do not succumb to the pressure, just wait and file it the next morning unless it's critical. So that's something in our control the timing as much as you possibly can. And the second thing, and I think this is a really important and salutary point, it's a bit like my learner driver. When I sit next to my driver or in the ditch panicking, I think I know how to drive. I drive every day. But I have to keep going back to the basics to explain how the driver is to learn. And I think appointments are very much like this. You know, every time I ask a trainee or somebody in my team to do an appointment, I say, please go back to the rules, please go back to the legislation, please triple check. It's not a case of just filling in the forms. And that, again, is in our control. The second point, pulling it together, is what happens if it does all go wrong. Well, the first point is don't panic, but I think we've now got a less bumpy road, because I think we've got quite a clear approach of how the judges are going to approach this. The Sonergy approach is the approach. They'll look at the intention of Parliament, so they'll focus on the consequence of non-compliance with the statutory requirement. They'll then look at, did Parliament intend or it to be an invalidity, a nullity, or did Parliament intend it to be an irregularity? And if it's the irregularity approach, they will look at what's the injustice and can I repair it? And if it's a nullity, they will look at the retrospective decision. And ARG sets that out really carefully in 5 questions. The judge goes through 5 questions, he answers. And I think that's our approach going forward. And just to throw into the mix, and I'm hoping Hugh's going to pick up on this, Hugh emailed me at, I think it was about 10 to 9 this morning. So when I'd written my slides, to tell me that there's another judgment, Glitchpay. Thankfully, I think we're still on message, Hugh, but I'll let you pick that one up.
Thanks very much, Joanne. Yes, on Glitchpay, that's another decision of Clive Jones sitting as an ICC judge, like in Token House, and it's a decision which is actually a fairly sort of conventional one from the point of view of invalid appointments, in the sense that the qualifying floating charge holder simply didn't have an ability to appoint at the time due to the fact that the charge wasn't enforceable. So it arose in unusual circumstances in the context of an attempt by a company which had been rescued by the purported administrator, an alleged misfeasance action using paragraph 75. And the judge rejected the application on the basis that it all depended on an allegation of acts as administrators, but they hadn't in fact been administrators, and therefore the whole action was misconceived as a result. But the actual question of the appointment of the floating charge holder was a relatively plain vanilla one, going back to cases really pre the Enterprise Act, where you have attempts to appoint a receiver which is invalid. So that's maybe just a sort of an end note to that section of the talk. Should we move on then and deal with part 2 of the talk? And part 2 of the talk is dealing with the question of the rule in ex parte James. If you want a short answer to this question, the headline question is where is the principle left following the decision of the Court of Appeal in Lehman Brothers Australia Limited and McNamara and others, a decision of Lord Justices Patton, David Richards and Newey, Lord Justice David Richards giving the lead judgment. And the headline answer is the wider unfairness test applies, judged by reference to the right thinking person, really judged by reference to whether or not the court adopting a conscientious and high-minded approach would consider it appropriate to allow the person to rely on their legal rights, not the narrower test of unconscionability. So that's the headline question, the headline answer. But just to get into a bit more detail in relation to the case it concerned an appeal brought by Lehman Brothers Australia against the dismissal by Mr. Justice Hilliard on its applications for directions in the administration of Lehman Brothers International Europe. LBA is a company incorporated in Australia, and it was part of the worldwide Lehman Brothers group and carried on on business in Australia, where it entered into liquidation in October 2009.
Hugh, sorry,
yeah.
the slides are not moving.
Okay. Shall I press take control again?
Yeah, see if it.
Has that worked?
Yes. Yes.
So apologies, everyone. So headline question, following the Court of Appeal decision, headline answer, wider unfairness test applies. If I move on to the next slide, so just dealing with the facts in the case stripped to their bare essentials, there was a settlement agreement between the two entities in the context of the proof process taking place, and the settlement agreement was in 2014, and then an error was discovered in 2016, and the value of a bond was wrongly converted into Australian dollars rather than euros, which resulted in a shortfall of 1.6 million. It was common ground that that was an innocent mistake by Libby, which was not spotted by LBA. LBA sought to vary the amount of the provable claim under what was then Rule 2.79, and the Libby administrators declined to vary, citing the wide release clause in the settlement agreement. The release clause, if you're interested in it, went along the following lines. There was a release applied to all claims, whether rising under the creditor agreements or not, whether in existence now or coming into existence now or coming into existence at some time in the future, whether or not in contemplation of LBA and or Libby and or the administrators on the date hereof. So quite a wide release clause. And the matter then came before Mr. Justice Hilliard, who was seized with three questions, really. One was, should the court intervene under the principle in ex parte James? The second was, could relief be granted under paragraph 74 of Schedule B1 on the basis that there was unfair harm caused to the creditor by the actions of the administrator? And in particular, can the rule in ex parte James be used to trump or prevent enforcement of contractual terms? The decision of the judge at first instance was that the principle should be governed by the test of unconscionability. That wasn't ultimately supported particularly strongly on appeal, and it went by the wayside on the appeal. But perhaps more significantly, he thought that relying on contractual rights would breach the principle, would not breach the principle or justify the invoking of paragraph 74 Schedule B1 relief, which of course uses the concept of unfairness. And he concluded even if the test was unfairness under ex parte James as well, given that the regime in place with these settlement agreements was to ensure finality across a wide range of creditors, that principle should not be invoked in order to trump that procedure. The Court of Appeal disagreed, and ultimately their reasoning was to go back and look at all the different cases and ask themselves what the test was, and they discerned that the test really was unfairness to take advantage of legal rights, not unconscionability. And in that respect, some quite heavy reliance was placed on obiter observations of Lord Neuberger in Nortel. But also, I think of the great significance of the decision was the emphasis by David Richards that what the court is applying here is not intended to be a subjective test, but is intended to be an objective test. So the court is asking itself whether or not a right-thinking person would, in fact, consider this appropriate. So it's not intended to be a attack or a criticism on the subjective intentions or motives of individual IPs. And so therefore, he felt that this wouldn't necessarily therefore become what some people have described as an unruly horse, so just a sort of an open texture jurisdiction, which is very difficult to apply. The Court of Appeal also said that paragraph 74 is not confined to cases of discrimination and could potentially be invoked to relieve a particular creditor from unfair harm on the circumstances of this case. So the appellant succeeded and they got their additional 1.6 million. you may have thought that actually there was an alternative route under the law in any event, because of course the court has power to rectify. And after the first instance decision, but before this Court of Appeal decision, we received the judgment of the Court of Appeal in FSHC Group Holdings Limited and Glass Trust Corporation. That's a 2019 decision. And in that case, the Court of Appeal re-emphasised that actually, save for where there's an earlier contract, a rectification of a contract is normally governed by subjective principles. And so therefore, it might have been open, having regards to looking at the email traffic which passed between the two counterparties before the settlement agreement, the CDD, was entered into in this case, to have mounted a rectification argument. So in lots of the ex parte James cases, you do wonder whether or not the court might in any event have had an ability to deal with the matter another way. But perhaps what it does do is it simplifies matters for those who are wanting to mount these arguments, and potentially throws open office holders to a wider inquiry in scope. They might want to ask themselves wider questions just simply than what are my legal rights, and have regard to codes of conduct and wider ethical principles when considering what to do. Ultimately, however, it's not a bad test to look at the extremes of where the law is considered to be and consider whether or not actually there might be the possibility of invoking some other jurisdiction proximate to it in order to decide whether or not you are inside or outside what is intended to be an objective test as to whether or not there's unfairness involved. So that's a whistle-stop tour through the rule in ex parte James. I did also want to just briefly mention, really by way of foreshadowing to part 3 of the talk, another case in the context of compliance. And hopefully, if the slide process is working, you'll now see a slide referring to Moss Groundworks. So Moss Groundworks was a case where there was an application for administration order brought in short order before the Manchester District Registry, and they had the good fortune or misfortune to have the matter heard before Mr. Justice Snowden, who was eagle-eyed in terms of his review of the application and spotted various inconsistencies in terms of the evidence provided to him as compared with CIP 16 compliance. To summarise, in effect, the applicants had engaged in a very short period of marketing and had not given a clear indication in the evidence as to exactly what had gone on in that respect. The time constraints involved weren't clearly set out in the evidence, and the result of the marketing was, surprise, surprise, only the connected party put in a bid, and they put in a bid for book debts with a book value of 819,000 and WIP of about 219,000 on the basis of paying cash of 25k and a further 105k in a month's time. There was no indication they'd gone to the Prepack pool for any independent review by the Prepack pool, and there was no indication either that they'd satisfied the marketing essentials set out in the appendix to CIP 16. So the judge said, no, I'm not going to grant it, but I'll adjourn it off and you can come back after the weekend and try and do a better job next time if you want. The matter did then come back in the list the next week, and there'd obviously been some repositioning. There was a detailed statement showing CIP 16 compliance, and further explanation was given as to the short period of time caused in part by concern that there was a substantial debtor who was about to pay the company, and therefore there were concerns as to timing as to when they did the marketing in order to ensure that that debtor wasn't frightened away from paying them. There was also an interesting offer by a director to forego a director's loan in the sum of £80,000, which might be viewed as being an acknowledgement of the interest in the connected party from actually acquiring the assets themselves, but was also considered by the court to be a fair acknowledgement and reflection of the good faith of the director involved. And the court was satisfied that the requirements of making an order were made out. The company was insolvent, and the purpose of the administration in achieving a better result than a winding up was clearly satisfied. The court did obviously echo the observations which are made in lots of other cases when there's an application for administration order in the context of a pre-pack. What it was doing was not, in fact, endorsing the case as being one which could not be subsequently challenged upon further review. So it's not a carte blanche, if you like. So that case, however, sets the context for the next section of our talk in relation to the question of the pre-pack reforms. And the pre-pack reforms obviously arose out of the 8th of October report on the findings and recommendations following the review of the measures introduced in 2015 following the Graham Review. The conclusion in the report was that whilst things had improved, more regulation was required, and that's the focus of this part of the talk. It was noted by Lord Callanan in the foreword to the report that pre-packs are recognised as a valuable part of the insolvency landscape and represent about 30% of the administrations, but there was concern still about creditors' lack of awareness or information and connected sales, and also there was concern that whilst there have been improvements, there were still significant failings on the part of compliance with SIP 16. In terms of the specifics in that respect, you'll see some of the stats in relation to the number of cases which were properly reviewed and contain, for example, viability reports. You may recall viability reports are intended to provide some reassurance that the new co is not simply going to fall flat on its face within a short period of time and not actually pay the consideration, which is often deferred. So that was indicated as being a concern. And there was also a concern as to the lack of the use of the pre-pack pool. And still 1 in 5 cases that were reviewed were non-compliant with SIP 16. So that set the context for a decision that some regulation was required. And back over to you now, Joanne, for giving us a bit more of the theme. You given the shortness of time, we can probably give the next slide or two a fairly sort of overview.
Yeah, definitely. So this is just a snapshot of the sort of history of how we've got to where we are. The eagle-eyed among I'm here, Hugh. Sorry,
you're back.
My internet bombed. I'm sorry. Always
That's right.
the way, hey?
That's right. You're back on now. I think for me, you're on slide 25, but it may be that others are on a different slide. But
okay. So the point from this slide is just that they've got until June 2021 to bring the non-draft regs into force, so the regs, and the message this week was they're not rushing, so I think we'll see those sometime probably in the spring next year. Hugh, can you move us on?
Yeah.
So I thought it'd be helpful if we had a discussion. So I don't know, Hugh, whether you can talk us through sort of when these regs, the draft regs, are designed to apply, in what circumstances?
Yeah, so the definition in terms of when they're to apply are in relation to a substantial disposal, which is defined as being a disposable hiring out or sale to one or more connected persons during the period of 8 weeks, beginning with the day on which the company enters administration, of what is, in the administrator's opinion, all or a substantial part of the company's business or assets. And a substantial disposal includes one which is affected by a series of transactions. If you want to compare with the wording in SIP 16 in paragraph 1, the term pre-packaged sale is defined there to refer to an arrangement under which the sale of all or part of a company's business or assets is negotiated with a purchaser prior to the appointment of an administrator, and the administrator effects the sale immediately on or shortly after appointment. I would tend to suggest that probably the regs are intended to reflect a similar concept, but they use the concept of substantial part rather than simply all or part.
And I think that definition, Hugh, of 8 weeks as well is quite prescriptive, isn't it? If that comes through, it's quite a long time. That for me is not in the sense of a pre-pack, but
exactly. So I mean that's made during the period of 8 weeks, beginning on the day of administration, is I suppose intended to try and capture some steps which the transition might be sliced up, I suppose, mightn't it? And so. In terms of making a substantial disposal, so when you're caught by that regulation, administrator must not make one unless Regulation 6 has been satisfied, which is creditor approval, or Regulation 7 has been satisfied, which is the report. And creditor approval obviously sends us back to seeking a decision from the company's creditors under paragraph 51.1 or paragraph 52.2 of Schedule B1. And in that respect, there's nothing particularly new about that process. And if the creditors approve the proposals without modification or with a modification which the administrator consents to, then all well and good. But I think probably what might be more interesting is just to look at the definition of connected person, Joanne, which I think is probably what you're going to deal with next.
Yeah, so I'm a bit exercised by this. So the connected person definition for, if you like, the buyer. So is the buyer connected, a connected person for the purposes of the pre-pack? The base starting point is familiar to us. It's in paragraph 60A3 of Schedule B1, and that refers to section 435 of the Insolvency Act, which brings in the definition of an associate. So for most of us, this is fine. You know, it's directors, it's shadow directors, it's officers of the company, it's their family members, it's employees and their family members. It's a company that's connected to another company, even if that's indirectly via a relevant person, and that connection point is tagged to control, and again, it's familiar. Control is the exercise of 1/3 or more of the voting power. Where I think this is interesting, and we'll have to see what the regs actually say when they come in, because I know the consultation process and feedback is still ongoing, is in our current procedure and SIP 16, there's a specific carve out for secured lenders. So even if they did exercise control of 1/3 and were connected in that way, they're not caught by the SIP 16 requirements. There's no obvious carve out in what we've seen at the moment for that arrangement. And when I think about the current, particularly mid-market distressed equity lenders, the types of funding available, and of course we're all seeing more and more money in the market for these kinds of businesses, you could see that that sort of rollover of debt type pre-pack might well get caught unless there's an exception. So a secured lender might indeed have to go through a mandatory process. I don't think it will apply obviously to a clearing bank, but for those distressed equity players, I think it's a point to watch.
So watch this space as to see whether they clarify that in terms of the wording or the guidance.
Yeah.
Okay, should we go on to the next slide, which I was going to ask you the question, Joanne. Do we really think that any connected parties are going to go down this route?
No, so this is the approval by creditors. It's difficult to see, isn't it, how when you think about your decision procedure and what hoops the insolvency practitioner has to go to even call a decision procedure, and the notice that has to be given, and the requirements then if there's 10% to call a different kind of procedure so that a majority can vote. I'm struggling to see how that sits comfortably with a pre-pack. You know, a pre-pack by definition is usually urgent. There's a big sensitivity around reputational damage. If it gets out, you want to preserve your contract so that suppliers don't suddenly stop supplying. And in this period between going out for the decision procedure and the decision being made, you know, who's going to fund the business? So I'm not sure that that process fits terribly comfortably with a pre-pack, but we shall see.
Yeah, so we're not holding our breath that this is going to be the new creditor engagement, which perhaps the regulations suggest they're wanting to try and encourage. But
yeah, So let's look at the alternative, maybe.
Yeah, okay. So the alternatives in terms of the procedure is obviously obtaining the Prepack report. And the report is, as things currently stand, defined by Regulation 7. And the concept of an evaluator is defined in Regulation 8. And the requirements as to qualification are interesting in relation to the evaluator. It's currently defined as an individual meets the requirements as to qualification if the individual believes that they have the requisite knowledge and experience to provide the report. So we seem to have a flagship reform which has self-certification at its heart, which is an interesting concept. Regulation 10, the requirements as to independence are set out in relation to that, and I don't need to go over this in too much detail, but the evaluator isn't to be connected with the company or with an associate, and knows or has any reason to believe there's a conflict, etc. So they're supposed to be genuinely independent people, and there are various exclusions, as you might expect, in relation to bankruptcy, etc., which is dealt with in Regulation 11. But moving on then to the form of the report, and who makes it? Of course, the report is produced by the evaluator and is supposed to include various formalities that they meet the qualification criteria. They set out their knowledge and experience. They identify the relevant property which is being disposed of, state the consideration to be provided, identify the connected person and their connection to the company, and include a statement. The key part, that the evaluator is satisfied that the consideration to be provided for the relevant property and the grounds for the substantial disposal are reasonable in the circumstances. So that's a case made opinion, or the evaluator is not satisfied of those matters, in which case it's a case not made opinion. And they have to include their principal reasons for that. So it's supposed to be a speaking report and include a summary of the evidence relied on, and include a statement that there's sufficient evidence for the evaluator to provide the statement. So that's the package, if you like. That's the key. That's really the key part of these reforms, which is supposed to give creditors greater confidence that that sales at an undervalue are not taking place, and that there is genuine and proper value being delivered for the benefit of creditors, even under an expedited procedure. There's then a procedure whereby subsequently that report goes to the administrator, who checks it. They have their own duties to ensure that there are no material changes, considers its contents, and checks that it's all in proper order, and then subsequently obviously sends the report off to creditors and to Companies House, etc. But so far as the consequences of the report are concerned, Joanne, it's not necessarily a binary outcome, is it?
No, it's not. And this will be interesting. So it's got a case opinion. So it's good. It's kind of been ticked by the evaluator. It's still incumbent on the IP to exercise their independent judgment. And actually, in practice, I don't think we'll see any difference in practice for IPs. You know, great IPs follow great processes. The current SIP 16 is pretty rigorous for most. The vast majority of IPs do this really thoroughly, and that will carry on, and so they'll exercise their independent judgment. Where I think it's going to be really interesting is if you get a case not made opinion, because by the looks of it, you can go out and get a number of different evaluators, so you're almost shopping around, or the purchaser is shopping around until he gets the answer he wants. So you could have, you know, case made and a case not made. Well, what do you do then? If you've got a case not made and a case made, would an IP go forward? I don't know. Obviously, they're going to exercise their independent judgment. The backstop, of course, brings us right back to, well, in all circumstances, you could go back to a creditor decision. But for the reasons we've articulated already, I'm not sure how that's going to work. So it will be really interesting to see how this plays out.
Yeah, and I mean, I think the report, the regs don't really spell this out, but I think the report in paragraph 7.3 does suggest that even where the report is made on a case not made basis, the administrator can still proceed. But in those circumstances, obviously, they have to justify their decision, and that may be, but it depends on the facts. Each of these things depend on their facts, don't they? But
it does,
there may be a sort of a very, very quickly changing picture in terms of the value of the asset or whatever. But
and of course, the purchase is important in this as well. You know, if they've got a case not made, but the IP is prepared to transact, does the purchaser actually want to proceed? It's a bit unsatisfactory.
It may be, or does it mean that actually we get more value for creditors because indirectly this might provide sort of the spectre of another of a you know, when there's only one purchaser in the town, so to speak, yeah. Whether or not this is a route that can be used to actually drive up value for creditors overall, potentially along the similar lines to Moss Groundworks, the initial decision being no, you need to do better. Maybe that will encourage some rigor. It remains to be seen. The proof is in the eating, I suppose. But in terms of course, we're talking about draft regulations, aren't we, Joanne? And so there remain some unanswered questions as to all of this. In terms of timetabling, there is actually a need to do something if they're going to do something under the current parliamentary timetable, because the power to bring this in, I think, expires under the relevant provisions in the Insolvency Act, which were extended by SEGA to, I think, June 2021. Correct. So they're going to need to do something during that period, if and it sounds like probably spring is most likely. There are issues of cost, aren't there? How much will a report cost? I suppose that will depend on the nature of the report, what it's dealing with, and how complicated it is. But it's another potential layer of cost, or is it? I mean, would good IPs be going out there and getting some decent valuation evidence anyway from third-party independent people?
Yeah, and I think the big question for me is, what role does the Prepack pool still have to play? The intention is that it will still continue. In fact, it's just received some more funding, and they probably are the natural point for independence and probably for setting a benchmark for what these reports look and feel like and how much they'll cost. But it's all to play for, and I think they're also negotiating with the regulatory bodies about the amendments that are needed for SIP 16. So I think, Hugh, this is probably another topic again for your next year's 1 year in administration for Guildhall series.
Well, with one-liners like that, Joanne, you're going to be invited back. So, in those circumstances, we've overrun a little, but I think probably now is the time to draw up sumps, so to speak, on this talk and give people an opportunity to ask questions if they want to on the chat function, because I'm sure everyone's got a busy day ahead of themselves and have other things they want to get on with. So should we throw it open to the floor now? And if people want to ask questions on using the chat function, please feel free to do so. Or if you want to adopt the old-fashioned approach and unmute your mic to say something, then in extremis we would allow that, but we would discourage it because it might end up having a clamour of voices at the same time, which probably wouldn't work particularly well. So if we can try and use the chat function, please, and if there are any questions, fire away. Whilst we're waiting for a question, Joanne, the only other point I was just going to raise was, how far will this actually stop the abuse, if you like? So if we've got an IP who's not doing with their 616 compliance properly, is this procedure actually going to add a sort of a further useful part to the exercise or not, really? It's open to doubt.
Yeah, I mean, my view on this is when IPs do prepacks, they do them very thoroughly anyway. The amount of hurdles that go through their internal regulatory compliance, etc. You know, I think we've got statistics from the very few, the minority that probably don't follow the right process. So I'm not sure this is going to achieve what the government is hoping it will, because I don't think it'll produce anything different to the quality I'm used to working with on prepacks as they are now.
Yeah, I mean, and if you look at the report, actually the stats were going the right way in terms of 616 compliance, weren't they? I think they were down from about 30 or 40 non-compliance 3 or 4 years ago down to about, well, 25% or less in the last year. So the figures were going in the right way in terms of the review work performed by the regulators. And
there's a point about messaging, isn't there? You know, the media, the media have a big responsibility in this. How they present a pre-pack and how they present the stories around it create the abuse, if you like, because that's suggesting that this is not a good tool. And really, it's incumbent on us as an industry to get the message across that this is a really, really useful tool used in the right way, which is part of the armory that is our insolvency legislation.
I mean, I suppose one of the main concerns here is in relation to an evaluator. They're instructed by the company, aren't they, to produce this report, not by the IP, I think, if memory serves me correctly.
Yeah, it's by the buyer. Yeah.
So it's by so in relation to that, you know, you I suppose need to think carefully about how good the instructions are in terms of what they're being asked to look at from an IP perspective, but also they're self-certifying their experience. Have they got insurance? And you know, are they part of a recognized sort of body themselves which has regulations and standards? There's no need for these people to be IPs, is there? It's an unregulated, at the moment, unregulated concept.
It'd be interesting to see whether some IPs or people from our industry actually put their hands up to be evaluators, because you know they're doing that in their individual capacity rather than as part of their firm. So I don't know how that insurance will work for them either.
Have you had experience of the sorts of people who might respond on the pre-pack pool, Joanne? So what sort of backgrounds they have? Are they mainly IPs?
No, it's a mix actually. It's drawn from people from industry. I don't know the exact makeup, but I know when they were constituting it, they were very keen to make sure that it wasn't just IPs.
Yeah.
You know, it's business people. I think there's not valuers, but people who are familiar with how to value assets. In fact, the current criteria is such that you wouldn't have to have any experience of a distressed sale, which raised questions in itself when the pre-pack pool first came in.
Yeah. So it can be anyone with some relevant industry expertise might be considered to be someone who's appropriate.
Yeah.
But they might not have any professional background.
Correct. Well, you'd expect them to have some, but you know, you wouldn't know. My personal view is if I were acting for a purchaser, I think I would probably be looking to go to the pre-pack pool because it's an established body, and it's got not regulation around it, but there's been thought put around who those individuals are, and I guess to a certain extent thought around whether they're suitably qualified to be able to say, I can do this job.
So there is perceived, at least in the industry, to be a sort of a fit and proper person sort of threshold before they're into the pre-pack pool.
Yeah.
And I suppose the fact that they've already been doing it as part of that process is probably an advantage.
Yeah, although the speed with which some of the decisions come back, I've done a few recently where we've gone to the pool and the decisions literally come back instantly, and you think, did they really read all those papers?
Okay, yeah.
I probably shouldn't say that, but
under the pre-pack pool, is there a charge for that service at the moment?
Yes. Yeah, there's a fixed fee. I don't know what it is, but yeah, there is a fixed fee. It might be around about £600.
Okay, so it may well be that fee goes up if under the evaluator concepts and based on the amount of work involved. So the fact that they're not there's I mean, the fixed fee, does that go to the pool or to the person who's actually providing the fee? Do you know, under the pre-pack pool regime?
I go, well, it certainly goes from us to the pool. I suspect the individuals will get some cost cover because obviously, you know, they need to give a half day or whatever of their time.
Yeah. Okay.
Yeah.
But
well, we're inundated with questions, Hugh. We must have either bored everybody senseless or we've answered all their questions already.
Yeah, or they're just enjoying listening to the chat. I mean, you know, that's the new format for next year is a fireside chat about administrations.
We should mention Govinda actually before we close.
You're quite right. Yeah.
Govinda in Chambers has done a massive amount of work behind the scenes for this presentation. and I am enormously grateful because it ensured that I could get up to speed fairly quickly on their cases. So the notes which will be being circulated are with my enormous thanks to Govinda, because I didn't have to try too hard because all the hard work had been done. So thank you, Govinda.
Yeah, it's been a sterling effort on his part to help us prepare, and also reiterate the fact that we will obviously be sending out the slides and those companion notes prepared by Govinda to help anyone who missed any part of the talk or dropped off to look at the notes and the slides. And then it just falls for me to thank Joanne once again for joining us, and it's been really fascinating to hear your thoughts on all the different areas on administrations, and I'm sure that we will have another interesting round of cases and thoughts to share in the next seminar. So thanks very much. And by way of signpost, I suppose the next webinar is taking place next week. You'll probably, I'm sure, all receive emails on that, but from memory it's Simon Passfield and Ed Husband who are doing a slot next week. If my memory serves me correctly, it might be looking at void dispositions. The week after, I think we've got Holly Doyle and Rachel Lai doing something on the duties and breach of duties by IPs in relation to their duties as IPs. And then the week after that, I think we might have an offering from Stefan and other members of Chambers. So there's a few interesting sort of webinars coming up. Hope you enjoyed today, and thank you very much for joining us.
Thanks.
Goodbye.
Hugh.
Cheers, Joanne. Bye.
Bye.